Whilst the numbers of people becoming aware of gross irregularities in the governance of Australia and other Commonwealth countries continues to grow at an accelerating rate, there are a few points of law causing major confusion and cognitive dissonance in the minds of many people. The two most important of these are the existence of and adherence to in the belief systems of many Australians of the 1901 Constitution, and the virtually total lack of understanding of the meanings of the words democracy and trial by jury. Evidently, there needs to be a more determined campaign to correct these misconceptions. When sourcing these errors, we find that they stem from a wide-ranging ignorance in the general population on basic points of law, including the origins of law, the hierarchy of laws, and the difference between the terms law and legislation, or lawful and legal. Many people use the terms law and legislation interchangeably, but they are not interchangeable. They each have a distinct meaning, the understanding of which is vital to comprehending the validity or otherwise of government legislation or edicts, mandates, etc. Put simply, a law is something that is immutable. We cannot change it, nor can we violate it without certain consequences inevitably following. The most obvious examples are physical laws, such as gravity, the speed of light or sound, etc. But such laws also exist in the non-physical, or what some people term the spiritual realm. Some of these relate to what we call rights. For example, every living thing will normally seek to prolong and possibly improve the state of its physical existence or well-being. Each person has these rights as part of the natural order of things, and they apply equally to everyone. No one can willfully violate these rights in another person without committing a crime against that person, for which the victim may lawfully seek redress via the judicial system. The purpose of the state is properly to uphold these individual rights and see to it that those who refuse to abide by the common or natural law and cause any harm or loss to others are duly held to an account in an orderly and evidence-based manner. The purpose of the state, then, as iterated by Spinoza, Locke, and many other philosophers, is not to control people, but to enable them to live as free beings, as naturally occurs in the wild. This understanding that the state's only proper purpose is to protect individuals' liberties and preserve what many people term God's law, and secularists call natural law, was the purpose behind the composition and adoption of the Magna Carta, or Great Charter of 1215. Thus, when we read that document, which is the primary document of the English common law constitution, we see that it doesn't grant any rights. It merely states that the monarch or their assistants shall not abuse those rights which already exist, and specifies various actions which are forbidden to those acting as administrators of the realm. There are no restrictions placed upon the individual, and only one instruction to the general population, which comes into effect if Article 61 is invoked. At all times, an individual is free to either comply with or commit breaches of the common law, or that instruction is Article 61. What we are not free to do is to escape the consequences for such breaches. In the case of breaches of the common law, we should expect to be held to account by a jury of our peers, as specified in Article 39. In the case of breaches of not swearing or affirming to uphold the Constitution, as outlined in Article 61, the penalty is that the individual, and often many others who may be reliant upon that individual doing their constitutional duty, must continue to endure unrighteous dominion, even tyranny, from unlawful administrators of state who are not called to account or trial by jury. This is exactly as it should be according to natural law. Failure to call out and lawfully resist evil is tantamount to consenting to it, and anyone doing this is actually voting with their feet to continue in a greater or lesser degree of slavery to those who seek to impose their wills unlawfully on others. It's a simple concept, really. So how does this relate to the 1901 Australian Constitution? An important maxim in law is, first in time, first in law. The meaning of it is, unless a subsequently drafted law is clearly superior in terms of upholding common law principles, the earlier law retains jurisdiction or precedence over the newer. In English law, nothing has been drafted that protects the rights and liberties of natural or God's law better than Magna Carta 1215. In fact, most subsequent legislation detracts from the rights and liberties of Crown subjects. Examples of that would be any tax law. That's a clear breach of natural law, which specifies that all are equal before the law, and that none has either the innate right nor a granted one to command any fellow subjects, and certainly not to steal or take without consent from one's neighbours. When we look up theft in the dictionary, there isn't any rider or disclaimer saying, unless the king or the state does it, then it's not theft, is there? Let's do a mental exercise. Imagine that there is no 1901 constitution, that it never came into existence. What would be the position of an Australian resident then? The position would be that we would all be living under the English or British constitution as laid out in Magna Carta 1215. The problem would be that virtually no one would know or understand that. Why not? Because it has for centuries been the work of the legalese profession and the wealthier elements of society to weaken the influence of Magna Carta and obscure the people's knowledge of their innate rights, replacing them in the people's minds with the false rights granted by statute, which can, of course, be negated or removed by subsequent legislation, while nibbling away at those natural rights which remain, with creeping demands and restrictions upon what people are innately free to do with their lives. The very definition of the word legal, as defined in Black's Law Dictionary, means the undoing of God's law. The population has been conditioned over hundreds of years to accept the view that someone has to be in authority over everyday matters and that it's futile to resist such a monolithic entity as the government. Then along comes a group of apparent patriots pressing for our own Australian constitution, where Australians can elect their own representatives and ostensibly govern themselves, without much influence from their mother country, as it was frequently termed. Sounds very appealing, doesn't it? Even today, given the woefully inadequate knowledge of natural or constitutional law amongst the population, it's easy to imagine this proposition being acclaimed by most as a step on the road to national adulthood. Isn't that how it was sold to the inhabitants of Australia in 1900? But let's also imagine that if it could be revealed to this credulous people that under Magna Carta they already had every freedom existing in nature, protected in perpetuity, with an article enabling the people to become the lawful authority should the monarch or their assistants ever go too far over the mark, would they then be so keen? When it's pointed out that under the proposed new constitution, many of those freedoms would no longer exist, including the power to dismiss the government and have the people assume the right to self-governance, would that look so good in comparison? What of the provisions in Section 71 of the 1901 Australian Constitution, which asserts that Parliament is sovereign and may appoint High Court judges and such other courts, investing them with federal jurisdiction as it sees fit? Where is the separation of powers? What is to prevent the legislature, the judiciary and the executive branches eventually moving in concert to assert untrammeled dominance over the population? Is not a proposal to grant power to draft, enact and enforce legislation to any one entity a textbook definition of a dictatorship or legislative tyranny? What intelligent individual, faced with the choice of virtually unlimited freedom from interference, or alternatively, total dominance by a group of so-called elites, would opt for the latter? Yet that was the choice facing the Australians of 1900 when presented with their homegrown constitution, which had been heavily redacted and redrafted by the UK Parliament. The problem is, no one revealed to them that that was the nature of their choice. The vital information about Magna Carta 1215 and the devastating contrast between that degree of freedom and the institutionalised form of slavery written into the Australian Constitution was withheld from the electorate while they were asked to vote on it. Withholding relevant information when seeking agreement from another party to any contractual arrangement is indisputably fraudulent, a crime for which there is no statute of limitations. Such fraud vitiates any contract. There is also the question of whether somebody voting for a fraud in 1901 can possibly lawfully or even legally bind someone living 120-odd years later. With Magna Carta, each Crown subject is not a signatory to anything. The whole thrust of it is simply to remove any imposts on an individual's freedom. There are no obligations apart from adhering to the common law, with any accusations as to failure to do that to be settled by a jury of one's peers, not a government employee or appointee. Supporters of the 1901 Constitution, while they may be motivated by some form of nationalistic fervour, are seriously amiss in their assessment of the principles of constitutional law involved. They run headfirst into the maxim stated at the beginning of first in time, first in law. The 1901 Australian Constitution, when considered with the magnificence of the concept of Magna Carta, brings to mind a picture of a superlative banquet alongside which is set a dog's breakfast composed of stale, leftover concepts of despots' rules from ages ago, mixed with indigestible concepts of parliamentary sovereignty and wrongly defined terms like democracy and justice. A mess of pottage at which no human with a true understanding of their own intrinsic value would even sniff, never mind consume. There is simply no worthwhile comparison to be made. The best that can be attempted is a contrast so stark as to cause amazement that people would fall for the trick once the true nature of the cards in play is revealed. Having highlighted the gulf which separates the freedom protected by Magna Carta 1215 and the institutionalised slavery of the 1901 Australian Constitution, the question arises, what is the individual to do in seeking amends? The first point of the answer is to stop appealing to those impostors who have already been suspended from Crown authority to continue pretending to be a lawful government. To ask for clemency from someone who has no authority to rule or punish in the first place is surely a very naive act. Even just asking such usurpers to act as if they still have authority is actually to assist them in their duplicity and treason, is it not? The instruction given in Article 61 is crystal clear. Once it is invoked, one is to swear or affirm one's allegiance to the Constitution via the constitutionally appointed officers, the Committee of Barons, and to refuse to comply in any way with the unlawful demands of anyone claiming to represent the Crown. That is the law of the land. Another maxim in law is, ignorance of the law is no excuse. Having been informed of the law, it is an individual's responsibility to comply with it. Waiting for other people to also comply with the law is not part of the equation. It is your responsibility to uphold the law. The second point of the answer to the question, what are we to do, is to seek redress. There are currently people running around proposing newly drafted constitutions, differing organisations of administration of state and so forth, but these are unnecessary. What must come first is a mechanism to immediately place the people in control of the law, and that mechanism is the restoration of trial by jury, as discussed in video 18, Rearward Vision, Forward Motion. Once that is in place, the worst excesses of government officers can be negated, with them facing their own trials if their acts of legislation cause unwarranted harm to Crown subjects. Other improvements can be negotiated progressively from there. The constitutional powers of the jury to judge by their own consciences and to annul bad legislation if necessary already exist. It is only the duplicitous and treasonous legal profession that is withholding that information. Do your duty. Spread the word. People need to stop waiting for someone to do something about organising the freedom movement and just do their individual duties. That is all that is necessary for this corrupt system to crumble. The guidelines and the authority are already in place. Every individual would be wise to remember the legal maxim, the law favours the vigilant and not those who sleep on their rights. There is no escaping the natural law that each is responsible for their own lives and liberties. There is no way to outsource or evade those responsibilities without incurring a very heavy karmic price. The only correct action to take under the true Constitution, Magna Carta 1215, is to affirm one's commitment to it and to turn one's back on anyone claiming to exercise Crown authority. When one thinks about it, to appeal to false claimants of authority to continue their unlawful dominion can only be realistically classified as an act of cowardice. It can only be done while simultaneously proclaiming or believing that the Constitution is invalid, which is to commit the serious crime of sedition. Do think about it. Thank you for watching.